personally been following this Commission on Legal Empowerment of the Poor process since before it had actually started. And I know that there was a lot of concern, especially as you mentioned, one of the co-chairs, Hernando de Soto's approach on property rights has been a very polarizing one. And so it's really remarkable in this report how much how much you were able to reach a consensus. First of all, that not all the commissioners were right-wing extremists that I think there was a lot of concern about, but that you were able to pull this together. And I think that people who read this are going to find that it is a balanced. And so congratulations on that. I think I want to point out a couple things out of this framework that I particularly like. And I'm going to focus a little bit more on the property rights side of it because that's the area that I'm most interested in, or where I'm starting from. First of all, that property rights is only one pillar, and it only comes in the middle after these issues of identity and voice, and especially the information and education part of this. And with the objectives, the twin objectives of protection as well as opportunity. Because in a lot of cases, things that create opportunity may reduce people's protection. And we're certainly seeing, as various crises hit, not only food price crisis, but as natural disasters and things like that hit, that both of these are very important goals. So I think one of the concerns has been if property rights systems are brought from the extra-legal into the narrowly defined legal, that then it creates opportunity for those who have greatest information to take advantage of this. And, we've seen this in lots of countries where a titling program goes through and it's suddenly either urban elites are getting the titles or the chiefs are titling the land in their name, and a lot of these customary rights are left out. I want to highlight another important statement, and I can't cite what page this was on, but that there isn't just one model to import, that you study what's going on in the existing system and develop legal frameworks from that. I found a very nice analogy for that when I went to University of Maryland, and on their quad, they point out that there's almost any university quad, students have made their own tracks that are not the paved tracks. In University of Maryland, it doesn't happen. What they said they did was they didn't put any sidewalks in for the first year. They watched where the tracks went, and then they made the sidewalks there. And I think that's kind of a nice analogy for what needs to happen in drafting legislation. See what practices people have been using, what's been useful out of that, who benefited from that, and maybe you want to put up a fence someplace where people are already going because something needs protecting. But mostly, the more you can build from bring a harmonization, I guess, between the legal and the extra-legal, or these other forms of legality. So I very much like that. I guess the implementation is the big question. I know Uganda did a very good on the books land law some years ago, which included a lot of provisions for bringing the registration systems down to the rural areas. Unfortunate, which would have made it a lot more accessible for people to register their land and get formal recognition. Unfortunately, the Parliament then didn't appropriate the resources to fund those state bodies that are out there, and so there have been a lot of problems. Certain NGOs are using paralegals, which are helping, but it's how do you get that information and education out and the standing so that poor people really feel that they can go to court if need be. So those are but I think your point about power, and perhaps you'll have a chance to come back to this off the cuff, is how do you create that power to challenge the authorities?